Hi all, welcome to the Lucid main session by Ekam IAS, and today's topic is sedition laws. So, to do this, we are going to look at our topics, and they are why in news, what is sedition, then introduction, law of sedition, history, what are the activities that are seditious in nature, then sedition disloyalty in action, defenses available to a person charged with sedition, and sedition and Article 19(1)(a) of the Indian Constitution, then Indian freedom fighters who were charged with sedition, then should the Indian legal system abolish the laws punishing seditious activities, then cases related to it, acts which are not considered seditious, why should it be scrapped, what has the Supreme Court ruled, short-term measures, concerns, conclusion and way forward. We can discuss why it came in news. So, on January 14th, the Delhi police charged Kanhaiya Kumar and 9 others including Umar Khalid and Anirban Bhattacharya with sedition cases. So, and 3 years after, they allegedly raised anti-Indian slogans at the event at the university. Dr. Hiran Gohain and popular activist Akhil Gogoi, who were slapped with sedition charges last month for alleged dissentient comments during a public rally against the Citizenship Amendment Bill 2016. That is the second news. And the third one, it is sedition charges against 2 tribal leaders and 1 tribal human rights activist for participating in a rally against the Citizenship Amendment Bill at the headquarters of Tripura Autonomous District Council on January 30. So, these 3 are the cases which came in news. So, first let me explain what is sedition. Section 124(a) of the IPC defines sedition and says, whoever by words either spoken or written or by signs or by visible representation or otherwise brings or attempts to bring into the hatred or contempt the government established by law, or whoever by the above means excites or attempts to excite disaffection towards government established by law and has committed the offence of sedition. Then, according to the law, disaffection includes disloyalty and all feelings of enmity. However, disappropriation of the measures or administrative action of the government to obtain their alternation by lawful means is not an offence. So, this is what sedition. Okay, next is introduction. Every citizen has been given freedom to speak and express their views under Article 19(1)(a) of the Indian Constitution. However, this freedom is not absolute and some reasonable restrictions have been imposed on freedom of speech and expression under Article 19(2). But when a person does an act by his words, signs or representation which is held to be contemptuous words towards the government of India, then such act is punishable under section 124(a) of Indian Penal Code 1860. And sedition is an offence that criminalizes speech that is regarded to be disloyal to or threatening to the state. The provision of section 124(a) is very wide and it covers the act of defamation of the government, excluding any criticism in good faith of any particular measures or acts of administration. Then, law of sedition. The term sedition means conduct or speech which results in mutiny against the authority of the state. Law of sedition deals with section 124(a) of IPC 1860 and is considered as a reasonable restriction on freedom of speech. It was drafted by Thomas Macaulay and introduced in 1870. The following points describe the origin of the sedition law. Origin of sedition law in India is connected to the Wahhabist movement of the 19th century. This was an Islamic revivalist movement and was led by Syed Ahmad Barlawi. Since 1830, the movement was active But in the wake of 1857 revolt, it turned into armed resistance, a jihad against the British. The British termed Wahhabis as rebels and carried out military operations against Wahhabis. Let's see its history. In British era, Section 124A was not a part of Indian Penal Code 1860. But this section was inserted into IPC by the IPC Amendment Act 1870. By an amending act of 1898, this provision was later replaced by Section 124A. According to the British era law, under the old IPC, exciting or attempting to excite feelings or disaffection was considered as sedition. Okay, then let's see what are the activities that are seditious in nature. In India, what constitutes as sedition is highly debated. As per the Indian Penal Code, for an act to be called seditious, it should have the following components. Any words which can be either written or spoken or signs include placards or posters, that means visible representation. Then secondly, it must bring hatred or contempt or disaffection against the Indian government. And it must result in imminent violence or public disorder. As per the interpretation of the court on Section 124A of the Indian Penal Code 1860, the following acts have been considered as seditious. Raising of slogan against the government, example, Khalistan Zindabad by groups. Then raising of slogans by individual casually once or twice was held not to be seditious. Next, a speech made by a person must incite violence or public disorder for it to be considered as seditious. Subsequent cases have gone to further interpret it to include incitement or imminent violence. And another thing is that any written work which incites violence and public disorder, these are considered as seditious. Then, next is sedition found in other laws. The following are some laws which cover sedition law. That is Indian Penal Code 1860, Section 124A, and the Code of Criminal Procedure 1973, Section 95, then Seditious Meetings Act 1911, the Unlawful Activities Prevention Act Section 203. Okay, these are some of the sedition found in other laws. Next is sedition, disloyalty in action. The sedition has been described as disloyalty in action. The object of sedition law is to induce discontent and insurrection and stir up opposition to the government and bring the administration of justice into contempt. Sedition is a crime against the society as it involves all those practices that result in conduct disturbance in the state or to lead to civil war which contempt the sovereign and promotes public disorder. Okay. Next is defenses available to a person charged with sedition. To get the exemption from criminal liability, the following are the defenses. That he did not make the sign or representation or not speak or write the words or not do any act in question. Next, he did not attempt to do contempt or attempt disaffection, and such disaffection should not be towards the government. Then, next is sedition and Article 19(1)(a) of the Indian Constitution. The concept of free speech has attained global importance and all have supported it as a basic fundamental right of a human being. In India, such rights are provided under Part 3 and Article 19 of the Indian Constitution. The said right has no geographical indication because it is a right of the citizen to gather information with others and to exchange thoughts and views within or outside India. And courts have been given the power to act as guarantors and protectors of the rights of the citizen. And Article 19(1)(a) requires the freedom of speech and expression, but it has been bound by the limitation which has been given under Article 19(2), which states the permissible legislative abridgment of the right of free speech and expression. In Niharandu Dutt's case, for sedition, the federal court had taken chance to interpret the Section 124A of the IPC in alignment with British law. and it had ruled that tendency to disturb public order was an essential element under Section 124A. The Privy Council held that the incitement to violence or a tendency to disturb public order was not necessary under Section 124A. And next is, in Tara Singh West State, the validity of Section 124A of the IPC was directly in issue. In this case, it curtailed the freedom of speech and expression, so the East Punjab High Court declared this section void. So, by the Constitution, that is First Amendment Act of 1951, two changes were introduced relating to the freedom of speech and expression. And they are, first one is, it considerably widened the latitude for restriction on free speech by adding further grounds. Then secondly, the restriction imposed on Article 19(1)(a) must be reasonable. Okay. Therefore, the question now arises of whether Section 124A of IPC is in conflict with Article 19(1)(a) or not. So, it has been reflected by the following points. That is, first one, Section 124A of the IPC is ultra-virus the Constitution in as such as it infringes the fundamental right of freedom of speech in Article 19(1)(a) and is not saved by expression in the interest of public order. Okay. Then secondly, as the expression in the interest of public order has a wider connotation and should not be confined to only one aspect of public order, then the Section 124A is not void. Okay. And thirdly, Section 124A IPC is partly void and partly valid. In Indramani Singh West State of Manipur, it was held that Section 124A, which seeks to impose restrictions on exciting mere disaffection, is ultra-virus, but the restriction imposed on freedom of speech and expression covered under Article 19(2) can be held intra-virus. And in 1959, that is, Allahabad High Court declared that Section 124A was ultra-virus to Article 19(1)(a) of the Constitution. Okay. Next, we can see some of the Indian freedom fighters who were charged with sedition. Mahatma Gandhi was charged with sedition. Gandhiji had written 3 politically sensitive articles in his weekly journal Young India, which was published from 1919 to 1932, so that he was jailed on the charges of sedition. He was sentenced to a 6-year jail term, and 3 charges were imposed on him. First one is tampering with the loyalty, then shaking the mains and attempt to excite disaffection towards the British government. He wrote the first part of his autobiography during his imprisonment, The Story of My Experiments with Truth, and about the Satyagraha movement in South Africa, and he was released after 2 years as he was suffering from appendicitis. The next is Bal Gangadhar Tilak was convicted under this. Bal Gangadhar Tilak was charged with sedition on 2 occasions. Firstly, his speeches that allegedly incited violence and resulted in the killings of 2 British officers, for which he was charged with sedition in 1897, and he was convicted but got bail in 1898. And secondly, he was defending the Indian revolutionaries and called for immediate Swaraj or self-rule in his newspaper Kesari, for which he was convicted under sedition and sent to Mandalay, Burma from 1908 to 1940. Next, we can see, should the Indian legal system abolish the laws punishing seditious activities? So, it's a question. That is, in today's scenario, the sedition law expects that citizens should not show enmity, contempt towards the government established by the law. There are some dark areas which lies between actual law and its implementation. Thus, the laws need to amend those dark areas. In India, there are so many divisive powers acting together in which such laws are necessary evils in a country like India. And it is the need for such law that those activities which are promoting violence and public disorder should be stopped. Next, you can see famous trials of sedition. So, first one is Jogendra Sundar Bose. So, he was an editor of Bangobasi. He was charged with sedition for voicing against age of consent bill. Okay. And next is cartoonist Asim Trivedi. And during a rally of anti-corruption Crusade Anna Hazare in Mumbai, he had been accused for putting up banners mocking the constitution and posting the same on his website. And he was charged under Section 124A of IPC, Section 66A of Information Technology Act, and Section 2 of Prevention of Insults to National Honor Act. Next case is Kashmiri students. 60 Kashmiri students were cheering for Pakistan in a cricket match against India. So they were charged with sedition in March 2014. Okay. Next case is folk singer S. Cohen. He was charged with sedition for 2 songs criticizing the state government for allegedly profiting from state-owned liquor shops at the expense of the poor. And next one is Binayak Sen. He was a pediatrician by profession and was allegedly supporting Naxalites, for which he was charged with sedition by the Chhattisgarh government. Next case is Akbaruddin Owaisi. On December 22, 2012, he purported hate speech at Nirmal, and he was slapped with the charge of sedition by the district police of Karimnagar. Okay, and the next case is Kanhaiya Kumar, student of JNU. The JNU student leader Kanhaiya Kumar, he was arrested in February 2016 on the charge of sedition. He was arrested for inciting violence through unlawful speech and allegedly spread not all over India but also across the world. This arrest has raised political turmoil in the country, by which academicians and activists protesting against this move by the government. On March 2, 2016, the videos purporting to show this activity were found to be fake, and he was released after 3 weeks in jail. These are some of the famous trials of sedition. Next, we can see cases related to it. First one is Kedarnath Singh, West State of Bihar in 1962. A constitutional bench of Supreme Court held the validity of Section 124A, but laid down that a person can be charged with sedition only if there is incitement to violence in his speech or writing, or an intention or tendency to create disorder or disturbance of law and order. And next case is Maneka Gandhi case of 1978. The Supreme Court held that criticizing and drawing general opinion against the government's policies and decisions within a reasonable limit that does not incite people to rebel is consistent with the freedom of speech. And next case, that is Ramesh Thapar with Union of India. It pointed out the incompatibility of the law of sedition. Effort to ban publications on the purported threats that these pose to public safety were ruled unconstitutional. And in Shreya Singhal with Union of India, it declared IT Act Section 66A as unconstitutional. The court ruled that the speech, howsoever offensive, annoying or inconvenient, cannot be prosecuted unless its utterance has at the least a proximate connection with any incitement or disruption in the public order. Okay, and in next case, there is Balwant Singh and State of Punjab. After the assassination of Prime Minister Indira Gandhi, the accused had raised the slogan of Khalistan Zindabad outside a cinema hall. And it was held that 2 individuals casually raising slogans could not be said to be exciting disaffection towards the government. Section 124A would not apply to the circumstances of this case. Okay, these are the cases related to sedition. Next, we can discuss acts which are not considered seditious. So, improvement or alternation by lawful means with the disapproval of the measures of the government. Such actions are not considered seditious. Then the strong words which are expressing disapprobation of actions of the government and not encouraging those feelings which generate public disorder by acts of violence. And next one is to improve the condition of the people or to secure the alternation of those acts by lawful means. That means without the feelings of enmity and disloyalty which involve excitement to public disorder or the use of violence. Okay, these acts are not considered as seditious. Next, why should it be scrapped? Draconian laws such as the Section 124A only serve to give a legal veneer to the regime's persecution of voices and movements against oppression by casting them as anti-national. Is it time to scrap these laws? People concerned with the misuse of these laws often ask for them to be repealed or struck down on the grounds that they violate Article 19(1)(a). But herein lies the problem. Most of these laws have in fact been challenged and their constitutional validity has already been upheld. Section 295A, that is Deliberate and Malicious Act, intended to outrage religious feelings of any class by insulting its religion or religious beliefs. It was found to be constitutional in the Ramji Lal Modi case 1957, and Section 124A, that Sedition, was held to be constitutional in the Kedarnath case 1962. Both these were constitutional benches, and even though the effects of these judgments have been subsequently watered down through more liberal judgment, these cases remain the law of land. Okay. Next we can see what has Supreme Court ruled. The Supreme Court has persistently held that for the offence of sedition to be satisfied, there has to be a causal relationship between speech and acts of violence, and mere speech, regardless of how subversive it is, does not amount to sedition. Okay, that is what Supreme Court said. Then, what are the short-term measures? All speech-related offences should be made bailable offences. This would lessen the harmful impact of using arrest and custody as a way of harassing anyone exercising their rights under Article 19(1)(a). The offences should be made non-cognizable so that there is at least a judicial check on the police acting on the basis of politically motivated compliance. In the case of offences under Section 153A, that is promoting enmity between different groups on grounds of religion, race, place of birth, residence, language, etc., and doing acts prejudicial to the maintenance of harmony, and 295A of the Indian Penal Code, that is, it is mandatory under Section 196(1) of the Code of Criminal Procedure to obtain prior sanction of the government before taking cognizance of the offences. And this needs to be extended to the offence of sedition under Section 124A. In the case of hate speech, it is important to raise the burden of proof on those who claim that their sentiments are hurt rather than accept them as face value. And finally, it is crucial that courts begin to take action against those who bring malicious complaints against speech acts. What are the concerns? In the recent years, the ease with which complaints of sedition or speech that allegedly hurts the sentiments of a community are brought before the police and criminal action initiated against the speakers in a cause of worry. Figures of the National Crime Records Bureau, it revealed that in the 2 years of preceding the JNU case, there were a total of 77 sedition cases. Beyond the high-profile urban cases, the reach of Section 124A has extended even to faraway places. That is, an entire village in Kudankulam, that is Tamil Nadu, it has sedition cases slapped against it for resisting a nuclear power project. And Adivasis of Jharkhand, for resisting displacement, topped the list of those slapped with sedition in 2014. And let's see a conclusion. Sedition is a serious offence in the violation of Article 19. So there is a need that sedition laws should have expressly contained the words which satisfy the restrictions of Article 19(2). The purpose of restricting speech under Sedition Act is the protection of national security. And sedition laws should be interpreted and applied according to the guidelines given by the Supreme Court. And democracy has no meaning without freedoms, and sedition, as interpreted and applied by the police and governments, is a negation of it. Hence, before the law loses its potency, the Supreme Court, being the protector of the fundamental rights of the citizen, has to step in and evaluate the law and may declare Section 124A unconstitutional is necessary. Okay, and let's see a way forward. So, India of the 21st century does not require a law used by the colonial government to suppress India's voice. The guidelines of the Supreme Court must be incorporated in Section 124A as well by amendment to IPC so that any ambiguity is removed. And this will ensure that Section 124A of IPC strikes a balance between security and smooth functioning of the state with the fundamental right of freedom of speech and expression. So, that's all regarding the topic, and thank you so much for listening.